Hi cybersecurity class, it's Professor Opterbeck and I'm just bringing you the weekly update and again enjoyed reading all of your discussion posts from last week. Many of you observed that the Talon Manual's definition of what a cyber conflict actually means is ambiguous and refers to really the era of kinetic warfare. And I think you're really right to notice that ambiguity. That's one of the big problems that we face, obviously, in this question of cyber war. When we meet together in a couple of weeks for our first summit, I have two speakers coming who are really experts on cyber conflict. So Kenneth Geers, who you've read some of his materials in this class, will be with us, and Jamil Jaffer, who is a law professor as well as works in consulting, will also be talking with us. So kind of keep some of those questions front of mind for when we meet with them. To me, another one of the big issues is the fact that cyber conflict is, as we have seen, is pervasive. It's happening all the time. And that's thankfully not true with kinetic conflict. Well, in one sense it's true. There's kinetic conflicts going on around the world at any given moment. But from our perspective in the United States, we're constantly engaged in things in cyber, and if we were engaged in that many things constantly all around the world in the kinetic realm, it would be, much more noticeable. So the question is, when is it really an act of war? When do the laws of war really kick in or not? And nobody really knows the answer to that. It's going to be a really difficult and interesting thing for law and politics and diplomacy to continue to work through. So good work on that. This week we're moving now into 2 units where we're discussing questions of civil liberties in cyberspace. And one of the touchstones, as you'll see, is the Carpenter case, and you may have come across this case in some other classes. It's truly an important, kind of groundbreaking in many ways opinion from the Supreme Court, or really kind of set of opinions, because as you'll see, I'm having you read a number of the different concurring opinions as well as some of the different dissents, and just reflects the difficulty now of applying the Fourth Amendment, the law of search and seizure, in this new digital age when there are all these kind of more extensive ways of digitally gathering evidence. We will also kind of look more broadly at the questions of encryption, and I'm going to subject you to reading 2 of my papers that have to do with encryption. One of those papers concerns the Fifth Amendment and the extent to which turning over a password or that opens up a decryption key or the decryption key itself violates being compelled to do that violates the Fifth Amendment privilege against self-incrimination. And I'll say that I'm kind of in the minority among cyber prof type scholars in suggesting that I don't think in most cases that transgresses the Fifth Amendment. Many cyber prof scholars and most of the activist groups in the area, like the Electronic Frontier Foundation, think it does. But in my view, and if you kind of then look at my other paper on the Fourth Amendment and encryption, to me the interesting question is the relationship between the Fifth Amendment and the Fourth Amendment. Because the Fourth Amendment is really where we focus on the scope of search and seizure law, and that's what the Carpenter case is getting at. And by the way, I wrote that paper before Carpenter was decided, but you can kind of see that push and pull, or that tension of how broad search and seizure is going to be under the Fourth Amendment, and then how that relates, if at all, to the testimonial privilege when it comes to things like turning over passwords that might unlock the decryption of something like a hard drive. So think about those things as you read through these materials. I also gave you some of the basic statutes that allow the government to access electronic information short of a search warrant. And as you'll see when you read through those statutes, as well as the Wiretap Act, are necessary because of something called the third-party doctrine. And you'll see some of this as I discuss it in some of those papers. But the idea is, if you disclose something to a third party, the government can get that information from the third party without having to serve a search warrant on you. So if that third party voluntarily cooperates, that's kind of too bad for you, because you let that information go. You released it. You kind of gave up your right to privacy as against the government through the Fourth Amendment by giving that information to a third party. So what does the third party doctrine do? And Carpenter addresses this, as you'll see, of course, as well, when you're giving lots of information into the care of a technology company like a Google or an Apple or something like that. That's one of the really big questions we'll also begin talking about, and we'll continue to move into those questions next week. So have a great week, and I will see you online.